Kia ora koutou. Thank you, colleagues, for joining us today during Privacy Week. My name is Lloyd Quartermaine. I'm part of the communications team here at the Office of the Privacy Commission, and it's my pleasure here today to be joined by my two colleagues from the compliance team who will introduce themselves.
Kia ora, it's so great to have you here. I'm Susan Allen. I'm the Compliance and Enforcement Manager at OPC.
Kia ora everyone, and nice to meet you. I'm Vinka Cisternas-Torres, and I'm a Senior Compliance Officer at OPC.
Cool, and as you will see today, our topic, part of the Busting Privacy Myths, is what you need to know about notifying individuals about a privacy breach. And the myth is it's all too hard and it's all too difficult. And my colleagues to the right of me will be explaining that it's not, that it can be done well, and with some advice that we're about to present to you, there is a way of doing it, and we will talk through that today with you. There is an opportunity to ask questions. Many of you will have done tuned into previous presentations, so there is a Q&A button there. So please put your questions in, and if possible, we'll get to as many questions at the end as we can. So without further ado, we will begin. And our first question, which my colleague Susan will answer, is what are the notification requirements under the Act?
Great. Well, in this context of this webinar, we're talking about notification to people whose personal information has been impacted by a privacy breach. So there's also the option to talk about notification to OPC. That's not what we're covering here. We're also talking about notifiable breaches. So that is breaches that reach the threshold of being likely to cause or have caused serious harm. So that's set out in Section 113 of the Privacy Act. So the things we're talking about today are specific to those notifiable level breaches. That said, the same principles can be applied to non-notifiable breaches, but that's not a requirement of the Act, it's more a choice of the agency. So the key bits of the Act we'll be talking through today is Section 115, which talks about, says that an agency must notify an affected individual and sets out a framework for doing that. We'll also be talking about Section 117 that lists the things that agencies need to include in their notification to affected individuals. So there are some specific things that are set out in the Act that must be part of that notification. And we'll also talk about exceptions. So the Act does permit for certain scenarios where it's not appropriate or may cause greater harm than good to notify affected individuals. So that's Section 116 that we'll be talking through as well.
Cool, thank you. Now, we now talk about why, the great question of why I need to notify affected individuals.
Yeah, so there is one fundamental rule in privacy, and is transparency. Our advice to all the organizations that have suffered a privacy breach that is likely to cause serious harm or that has already caused harm to the affected individuals, to notify them as soon as possible after they have learned or became aware of the incident. And why is this? This is because you will give affected individuals enough time to protect themselves. People can change their passwords, people can monitor their bank accounts, and they can take any other action to protect themselves. By not notifying, people are not alert of the potential harm that can come their way. And it also is about building trust with your clients and with your staff, depending on the context of the privacy breach. So what does it actually mean as soon as practicable? Well, in terms of when we require you to notify us, we give you a time frame of 72 hours. And our expectation is that within that time frame, you are making the assessments, assessing the risk harms for the affected individuals. And by the time that you notify us, you have a better knowledge than us about the consequences of the privacy breach, and you will be prepared to notify the affected individuals.
Cool, thank you. Now another very, very important question. What do I need to notify?
So this is Section 117 of the Privacy Act that I mentioned at the beginning. So it sets out in detail what needs to be included in the notification. So a lot of times agencies do some of these, but not always all of these. So we thought it useful to set out the full set of requirements within the Privacy Act. That's largely around reducing the harm and being transparent, as Vinka said, with the people whose information has been impacted. So describing what happened, what information has and hasn't been disclosed out of the information that you hold about that person, where it's gone and who might be in possession in it, particularly if it's a malicious attack. So you've had a malicious cyber attack that raises the risk of harm of that personal information being put to misuse, as opposed to if it's just gone somewhere in error, which is still a risk, but less. And it's really important that people know what you're doing to reduce or control the harm. So if the information has gone somewhere else, can you get it back? If it was on a laptop, was the laptop password protected? Can you remotely delete the information on the laptop, that sort of thing? And also what support you can offer to help people protect themselves. So this is about you taking steps as an agency to reduce harm to the individual, but also them knowing individuals knowing what they can do to reduce their own harm. So that might be things like letting their bank know that their bank account details, for example, might need to have an alert put on it. What support you can provide as an agency in terms of helping them replace a driver's license if it was a driver license information that was stolen, that kind of thing. It's important that individuals know they have a right to complain to OPC and that information is provided on how to do that. In the first instance, we expect individuals to make complaints to the agency that held their information, and then we get referred after that if the individual is not happy with how that was resolved. And so in order to get in contact with you, they need to know who they can get in contact with, make it easy for them to find out and answer any concerns and questions that they have. It's also good to notify them that you've told us so that they know that we are providing the necessary support and guidance to agencies. In terms of notifying OPC, it's good for us to know because A, it's a requirement of the Act, but also it means that we can then help agencies who've had a privacy breach work through the notification requirements, work out what they do know and can tell people and what they might know later and can tell people later. You can do it in increments depending on what you know at the time. And it also means that OPC can just provide general guidance in terms of responding to the breach itself. It's important when you're notifying to be mindful of what you don't need to tell people. So for example, if there was employee browsing and an individual's file was looked up by a staff member, you don't need to tell that person the name of the staff member. You don't want to create another privacy issue by trying to resolve the first one. And so we can, if you're not sure, we can provide guidance on those matters as well in terms of the notification requirement. Yeah, that's all on that one.
Oh, that was very timely because we just had a question on exactly that. It's, for example, like employee browsing. And the question is, could it be frustrating if somebody knows their privacy has been breached, but they do not know the full details of that particular breach?
It absolutely can be really frustrating. And it's sometimes you have to be balancing what you need to tell the person in terms of the Act, what is good information for them to know in order to mitigate any concerns they have, because people do get very stressed and very worried when their information is breached as part of a privacy incident. There might be some instances where it is appropriate to give a bit more information about what happened and about within the agency than others. So that's very much a it depends situation. But in that scenario, I recommend you get in touch with us. We'll already be in touch with you if you've got a notifiable breach, and we can guide you through each particular scenario.
Sure, thank you. Now, the next question, another very, very good question. Do I always need to notify?
Mostly always, yes, if there is a serious harm privacy breach, but there are some circumstances that you can apply depending on case-by-case basis, and you can apply them under Section 116 of the Privacy Act. So some of the examples is if notifying the affected individual prejudice the security or defense or international relations of New Zealand, or prejudice the maintenance of the law by a public sector agency, or endanger someone's safety, or reveal a trade secret. In relation to those, the ones that we most often see that agencies apply are prejudice the maintenance of the law by a public sector agency. So let's say you have a privacy breach that has been discovered it was done for criminal act. And you get the police involved, and the police are investigating into the matter and trying to find the perpetrators or the actors of the crime. It won't be feasible to notify the affected individuals at that point in time, so you can consult with the police, and under their advice, they will be able to tell you whether it is feasible to do so, and then you can inform us about those results. When it endangers someone's safety, it also is an interesting one. When it says someone, it's not only the affected individual, but also you have to think on the bigger scheme. Could be someone within your organization. If it was about employee browsing and it was obvious who was the person who browsed the information, you may not want to notify the affected individual if they will easily identify your staff member, and that will have repercussions against your staff member. So you need to have those analyses. However, in any case, when you are applying for an exception, you have to tell us specifically which is the clause under that specific section that you're applying for, and explain to us why exactly you're applying for this. So we need more information. It's not enough to say we think that it will endanger the safety of our staff, but how, we will ask you how it would endanger the safety. So there are other circumstances as well where you can apply an exception, and it's when we are talking about people under the age of 16 or children. Obviously, a child will have no comprehension of what is a privacy breach and what are the repercussions of it to them. But in saying so, you need to also think about the harm that the privacy breach will cause to that child, and that perhaps other person needs to know, like the parents or the caregiver, and in those circumstances, you will have to make that assessment and contact their parents and let them know to protect that child. There is also the circumstances about the person having a mental health issue or problem, and in those circumstances, you could apply for an exception. It's normally applicable to health agencies, and what we require is for you to have an assessment made by a practitioner that can tell us the reasons why you are applying for that specific exception.
Just to add to that too, the point around notifying a representative is really important. So the Privacy Act and our internal approach is notify by default unless, and so there's a bit of a step down. So you notify the individual, assuming the prejudice, the security defence and the maintenance of the law is not applicable, and the trade secret is not applicable. If you can't then notify an individual because they are, for example, a child or a vulnerable person, then the next automatic step is to look at their representative. So it could be, as Vinka said, a mental health practitioner or a parent or a guardian or some other person who's supporting that individual. And so it is really important that notification to a representative is considered as part of the wider notification process. Within our office, we do put an extra level of due diligence across agencies that are providing a rationale for delaying or not notifying. The delaying notification exception one is particularly applicable to instances where, for example, a cyber hack, and you're not yet, something's happened, but you're not yet clear who's been affected, that information has been affected. So you're not actually yet in a position to be able to answer the questions in that section 117 requirement to notify. So in that case, it is possible to delay notification until you have more information. Telling people that something bad has happened without telling them what or how they can protect themselves can sometimes make it worse. So do think about that delay notification option as part of that. It is a point in time assessment. So as the breach investigation process continues, or as you find out more about what has happened within your organisation and to the individuals, you always check in on, does the thing that's happened now change the threshold for notifying? So it's a continuous conversation that goes throughout the breach management process.
Yes, and in addition to that, we work on an ongoing basis with the agencies when they report privacy breaches to us. So we do, as agencies, if an exception has been given, to continue assessing it. And if there is any changes on the investigation, to come back to us and let us know, and we can provide you the appropriate guidance.
Cool, thank you. It's only fitting that this week's theme is busting privacy myths. So now we're going to look at some of the myths about notification that your team has come across.
Yeah, so these are some of the things that feedback we get from agencies when we talk to them about notification. One of them that comes up a lot is where an individual has contacted the agency and said, hey, I've received someone else's information by mistake, or I've been told that my information has gone to the wrong place. And then they then tell that agency. And so the agency says, well, I don't need to tell them about it. They already know, which they do. But pointing back to those Section 117 requirements, there's some other things in there that they need to be told as well. So the fact that they told you and they already know about it, just keep in mind, do they know all of the requirements? Have you formally told them of all of the things in that Section 117 issue? Another one we get a lot, and this happens particularly where it's an internal breach within an organisation. So it becomes part of an HR investigation or some other process. And so there's often a tendency to want to wait till the end of that process is finished before any notification happens or anything else happens. From our perspective, during a process such as that, there becomes a point in time at which the agency becomes aware that a privacy breach has happened. And at that point, the requirements of the Privacy Act kick in, provided they're not going to interfere with any investigation, of course, like an HR investigation or a police investigation. But just be mindful that it is a constant check-in process, as we were saying, along the breach management response plan. Don't need to wait till the end of an HR investigation, for example, to notify either us or the individuals. Another one we get a lot is something has happened and the affected individual's been informed and they're not concerned, and so the agency says, great, we're all good, no harm caused. Often we find that on reflection, people whose privacy has been breached do become concerned. They're not immediately concerned, and when they have some time to process and think it through and think about the risks that have been introduced because of the breach, they are then concerned. So just be mindful that just because the affected individual isn't concerned, it doesn't mean that there isn't likelihood of harm. Harm can come from a lot of different sources, and if the individual isn't worried, that's not necessarily a threshold that you apply. Vinka's going to speak to the other two.
Yes, so other questions that we often get asked is, I do have a large privacy breach, and there are different levels of information that has been compromised amongst different groups. How do I notify them? Do I notify differently affected individuals amongst this group? So we would say yes, and during your assessment, you have to analyze the level of risk. For some people, a wide range of personal information would be compromised in a privacy breach. It could be things like the full name, the residential address, the phone numbers, but also the identity information, like a copy of the passport bio page or a copy of the driver's license. Of course, it becomes more serious and more likely that there could be identity theft with those individuals. So we will say to you, yes, these individuals are in the group of likely to be serious harm for them, and that you need to notify them as soon as possible. Whereas for other groups, the information compromise might be less, and you might want to tackle in a different way. For instance, giving it through a public notice, a general public notice to the individuals that some information has been compromised, and then providing some updates around it. Also, you have sometimes privacy breaches that affect your customers and your staff. And also you can take different approaches on how you are going to notify your staff internally. Some organizations have asked, it's okay for us to talk one-on-one conversation with the staff member, and we say, yes, generally it's okay, but also do the follow-up in writing. So you have that backup for yourself that you have actually met the requirement of the privacy legislation and have notified affected individuals. So you could do it either by phone or in person, but we do advise agencies do the in writing one because it's best for you. Another one that we normally get as is who does notify, in terms who is the best person within my organization to notify an affected individual. And generally we say is up to the organization. Is sometimes it's nice to have, if I was an affected individual, have a notice from a CEO and people will take it very good. But also you have to think about who is closest to the affected individual, because every privacy breach is so different. Sometimes we do have privacy breaches that involve more than one agency. And you have to think also who is the owner of the information, and maybe the owner of the information is the agency that wants to take the lead and notify the affected individuals, because ultimately they are the main responsible organization that needs to protect the personal information. In terms of delay in notifications, well, we spoke about that aspect, and we do have frequent questions about delaying, and one of those is, do I need to tell everything in terms of the privacy breach if I'm still investigating the circumstances of the privacy breach? You don't need to, so you can actually approach your notification in stages and provide updates to affected individuals, and ongoing communication is the best for you.
Well, thank you. You mentioned before that there's privacy breaches are also different. So now we're just going to touch on basically the active notification and talk about when it goes right and when it's done right, when it's done well and when it's done not so well. So first of all, we'll got a couple of case studies. So we'll touch on when it's been done slightly less than optimally.
So case study one, a bit of a war story. So a small business was subject to a phishing attack, and that resulted in a third party coming in and taking over their email systems and contacting clients to tell them that the bank account number had changed for invoice payments. So the small business focused on securing their IT systems, and they didn't focus on responding to the privacy elements of the breach. So the clients were not told about the breach, and one customer in particular lost $150,000 as a result. So we were notified of this occurring, and the business was found to be in breach of Information Privacy Principle 5, which is around information security. So that was about having the reasonable standard of security settings on the IT system at the agency, which could have mitigated the phishing attack in the first place. But also in the context of this webinar around the notification requirements to the individual. So they didn't meet any of the Section 117 notification requirements. And the customer, as a result, couldn't take any steps to protect themselves or their money. So that was a really good example of how it can go wrong by not notifying. There was this one customer in particular, but others that were also significantly impacted that could have been prevented had the agency told them that they'd been subject to a breach and the nature of the breach, so the customer knew what to look for and protect themselves and their information.
Well, thank you. Now we're going to touch on when it's done well.
Yeah, so there is one of the aspects that we normally tell agencies, and is timely notification is so important, as the case that Susan just explained. And this one is on a very similar grounds. A financial services provider a while ago was subject to a cybersecurity attack, and they completely lost control of all their system. So there was a really highly likelihood that the hackers were actually exfiltrating personal information from their systems. Although not determined, this organization decided to take proactive approach to the privacy breach. They immediately notify our office, and by the time that they did the notification to our office, they have already, as a precautionary measure, put on their website to all their clients that they were subject to a cybersecurity attack, and they advise their clients to be cautious and worry about phishing emails, that they will not be sending any emails to clients requesting for payments or invoices, and just to be aware. And this is one of the things that we discuss a lot internally in our team and with the agencies, about that timely telling clients, protect yourself before something happens, because especially in cybersecurity incidents, hackers and scammers, they are very quickly to act. So at the time that they steal the information, soon after, they will be posting that information on the dark web, and they will be selling it. And then scammers will start getting those contact details like email addresses and phone numbers, and they will send the phishing emails, some of them to the point of portraying that they are the company, and getting the clients of the companies to pay for invoices, or doing all sort of other things that can harm people. So if you act quickly, that will help your clients, your staff, and everyone.
Well, thank you. After this presentation, you'll no doubt all be doing notifications very well. So we're now moving on to questions. I have a number already, but please feel free to send any more. So the first question is the expectation that the OPC are notified first and then impacted individuals?
Okay.
Okay. It all depends in the context of the privacy breach. So some privacy breaches will be very clear to you. And the example is the cybersecurity incidents. It's very clear that this is not done for the sake of doing it, and that your systems are not just compromised momentarily, but that someone is stealing information from your system. Especially if you receive that nice note called ransomware, yes, definitely information has been compromised, and you want to act quickly. So if it's in the means within your organization to alert your clients and your staff before you have alerted OPC, we are fine with it, and we will give you the big kudos for that. Other circumstances, other privacy breaches are more difficult. It's difficult to ascertain the risk level. So you may want to notify first us, and then wait for our instructions in terms of what are the next steps that you can take.
There is also, we have an expectation that agencies notify us within 72 working hours of becoming aware of the breach. And so there is no, as Vinka said, fixed rule about who to notify first, but it can take a while to identify all the individuals and do the notification to individuals. So it's a balancing of how do you protect, reduce the harm on individuals while also meeting that 72-hour expectations. And it doesn't need to be done in any particular order. Sometimes if you've got a big breach and you've got a team on it, you can allocate out the tasks that need to be done. Notification can take a while to individuals as you identify who, what, when, and what they can do in terms of preventing harm to themselves. So it's complicated.
Thank you. There are a number of similar questions on this topic. Should you only notify an individual when you actually know there has been a breach, or should you notify them if there may have been a breach?
That's a really good question. It is a bit of a judgment call, and it depends on the situation at the time. A good rule of thumb is to think about, is there any potential harm that could be caused by the breach? We often get notifications to us where it's in that grey area where you think it has but not quite sure and can't confirm. I would suggest don't notify if you're not sure enough to be able to answer those questions in section 117 of the Act. You don't want to cause undue stress on anybody if something hasn't happened. We have seen with some of the bigger breaches, agency will put out a public notice saying, this thing has happened, for example, we've been attacked by a cybersecurity hacker. We're working through it. We'll get in touch once we know. And so that if it's a big issue and you're really not sure, it's always good to go out with a, hey, just be careful. We'll come back once we know more.
And could I add, for what Susan was saying, is that earlier she mentioned about the framework. So there is a specific sections in the Privacy Act that you can refer to, where you have exactly what is the definition of a privacy breach, what is the definition of serious harm breach, and also the assessment of the likelihood, because it gets complex when you're thinking about harm has already happened, and that would be very obvious. But then when there is likelihood of harm is not so obvious. So you might be a little bit confused about that. And if you are unsure about that, what we normally recommend agencies is to report the privacy breach to us or use our assessment tool. And then wait until our lovely team members will give you the further instructions. They will ask you more questions about the privacy breach, and then they will direct you at the right path to follow.
So just for reference in your notes, that's section 113 of the Privacy Act that sets out what serious harm looks like in the notifiable question. And our assessment tool is on our privacy.org.nz website called Notify Us. And it has two parts to it, one of which is where you can do a self-assessment to test how much you know about the breach so far and whether or not that reaches the notifiable threshold. That is just a guide, so it's not the hard and fast answer. On that page, there's also the formal actual form for you to submit, to make the formal submission of a notification of a breach to us.
A question about clarifying the 72 hours. 72 hours or 72 working hours? 72
working hours, definitely. So we take a fairly pragmatic approach. The aim of putting that number on is, it puts us in line with a lot of other Asia Pacific privacy regulators who have a 72-hour requirement in some form, either in expectation or regulation. We're also wanting to help put a framework around the wording in the Act that says as soon as practicable, so we know that that's a bit vague. So just trying to guide that a bit more.
Okay, we've got a couple of questions about types of notifications. If an agency makes a media release about a security privacy breach, does that constitute a public notification?
Yes, in short. Vinka, do you want to add anything onto that?
Yeah, so there are different types, and sometimes you make a media release, and that could constitute, in our view, that you have done the public statement, or you could formally do a public statement through the website of your organization. So whichever is the best to the organization, especially when the privacy breach is still under investigation. And in saying so, what we recommend agencies to do is that despite you doing a public statement, where you can actually identify who the affected individuals are, do follow up with an email, do follow or do make a phone call and do contact them, because clients and staff, they do matter, and you want to have that closer relationship with them.
Cool, thank you. Now, what happens if you think there's been a breach but no one's told you about it, so you haven't been notified? What should you do?
Well, something led you to think there was a breach in the first place.
Yeah, maybe I belong to a bank and I think, oh, that bank's been breached and no one's told me about it.
So in the first instance, you go to the agency. So if you're worried that your bank has had a breach, but they haven't told you about it, then you can I would contact the bank in the first instance and ask them what they know. And they will then do some investigation and be able to confirm to you, yes, something has happened, or no, something hasn't.
Cool. And we just had a question about the questions, and please just pop any questions into the Q&A chat and not into the actual presentation itself. Another question is, and this is probably a difficult one to define, what makes a breach serious?
Not every breach is the same. So it depends on the context, and it depends on the nature of the information. So there are certain things, and we're gonna try to do here privacy one-on-one on privacy breaches. But one of the things that you need to be learning if you're a privacy officer in an organization is what actually does mean personal information and what does constitute sensitive personal information. So there are some information that is sensitive by default. For instance, health records are highly sensitive. Bank account details, they are highly sensitive. Financial information is also sensitive. There is other information that is not so much sensitive, but you will categorize as personal information, like for instance, my name, my date of birth, and my home address. But when you have only that type of information, you have to think about the privacy breach itself and the context of it. The one example that normally we utilize with agencies is the cybersecurity incident. That information was stolen from your organization. Is more likely than not that your client is going to start receiving spam or scam emails or scam text messages. So that will constitute serious harm or likelihood of serious harm. And then there will be information, for instance, that you might share no blank copy email addresses and send an email to another professional, and you balance that aspect whether is that other professional that I have sent information about my client someone who is likely to cause harm to those clients, maybe not. And then you could assess it as a not serious harm, but you have to put each aspect of that specific section 113 into context to be able to analyze it. And that's what our colleagues doing here when we receive privacy breach notifications. All the information that you provide to us, we analyze it into context of that specific section. And we are able to tell you whether we do agree to the assessment that you have done or whether we disagree, and we might think that this breach might be likely to cause serious harm, so you may want to take actions.
Sure, thank you. We've had several questions just trying to reconfirm the 72 working hours concept. So I'll get Susan to do that in a minute. But part of the question is also, is it 72 hours from when the agency becomes aware of the notifiable breach, and also touching into agencies have different working hours, and it might happen at the middle of the morning, or it might happen at the weekend. So I just wonder if you could give some clarification about what 72 working hours looks like to you.
Great, yeah, it is a question that we get a lot. So the 72, it's 72 working hours for your organisation. So if you are an organisation that works on weekends, then we would count that weekend time. If you're an organisation that doesn't, then we wouldn't. Having said that, if it's a really serious harm breach and where there is a risk of, a huge number of individuals being affected, or say a cybersecurity breach, we'd always prefer sooner rather than later. But at the same time, you don't get to have to come in on the weekend to do a particular notification on a particular thing that's happened. So we take a pragmatic approach. As I was saying before, our intent is to put a framework around the wording in the Act that's around as soon as practicable. So during that 72 hours is an attempt to do that. That puts us in line with other Asia Pacific regulators in terms of giving a bit of a guidance as to what that means, because we get asked a lot, well, what does that mean? So we'll take a pragmatic approach. If you're 73 hours, that won't be an issue, but if you're 3 weeks, then we'll be having a different kind of conversation.
Cool, thank you. Now, are non-disclosure agreements, or NDAs, valid?
Yes, I don't know. Actually, I'm not across this matter in particular. I would say, as a general rule, it depends on the agreement and the company policies. And yeah, I think that's not a question that I can answer at the moment. We could probably find out a bit more and come back on that one.
Cool.
If it's in the context of a privacy breach.
Yeah.
Okay.
Yeah, but
It seems it can be a little bit challenging to know whether to notify or not can people like call or ask us about pros and cons of notification? Is that something you suggest?
Absolutely. So we have an 0800 inquiries line, and they get referred on questions around should I notify or not come through to the compliance team. So we'll be able to take those calls and answer any questions and provide guidance.
Cool, thank you. There's also about ways of notifying people. What if is an email saying, "Hi Susan," is that okay?
In terms of the format, I think it's whatever works for you and your customers. So the way that you notify can help rebuild or not any trust that might have been lost during the breach itself. So think about your customer audience. How can you best give them the information that they need, but also how might it best be received by them? So in some instances, an email, I mean, all options are perfectly fine. It's just about whether with what would fit with your customers. So some might prefer a phone call. If you've only got one or two, it's often easier to do a phone call and follow up with an email. If you've got 100,000, then obviously that's not practical. So as long as the section, from our perspective, as long as the section 117 requirements are met, that's what we look for. But yeah, consider what your customers might want.
Cool. You're really going to earn your money here. What is the 0800 number?
I don't know.
Okay, neither did I. So
it's on our website.
We will answer that in a second. Yes, it is on our website. Now, so say I've done my job and I've notified somebody. Do I then need to do anything else? Do I need to go back and check on people, or do I need to see that? Do I have any additional responsibilities beyond that?
If you, as part of your notification, you're providing a contact number or a contact point for the individuals to contact you. And I think just good practice is to make a channel available for people to ask questions. They often do get very stressed and concerned. So being able to allay those by answering their questions and providing updates as you have them. Vinka, did you have anything to add?
Yeah, so initially in that notification, you want to put the detail about why the privacy breach occurred, because people will be curious about that. What exactly happened? Why my personal information was compromised in this privacy breach? And if you haven't provided all the information about the context of the privacy breach, have for sure that clients will come back to you and ask more questions. In terms of your responsibilities with our team, one is notifying us and giving us assurances that you have notified the affected individuals. So we do follow up with you to verify whether you have notified those individuals.
Well, that ties into this very similar question. So a third party advises you that they've notified the OPC. Can I check whether they definitely have?
So the OPC has very strict secrecy provisions. So information that gets told to us as part of a breach notification, we generally do not share with anybody. It's in Section 206 of the Privacy Act, so we hold that very tightly. There are certain circumstances where we might, but generally no. We might treat it as an Official Information Act request, for example. Generally, it will be held pretty tightly within the organisation.
Well, thank you. My only other question I've got is, where do I find out more about notifications? I assume there's material on our website? There
is. So the homepage of our website, privacy.org.nz, has a big button at the top called Notify Us, and that will take you to the page with the resources on about how to notify. It has our self-assessment form, and it has our formal submission form, as well as some brief Q&As as well, and contact details, including our 0800 number, which I will go and look up.
And we are updating our guidelines as well.
And we are updating our guidelines, yes. So that will be coming out in the next few months, I think.
Cool, thank you. I think that appears to be the end of all of our questions. Is there anything else either of you wanted to add before we go?
Yeah. So now that we in here, my advice for the organizations is do have a plan for notifications. What you have to do, what you have to assess, how do you have to notify OPC, how do you go about notifying affected individuals, and how do you assess that privacy breach. And another one that many organizations miss is like, what can I do in the future to prevent this privacy breach to happen again? have a think about it and develop your plans. And yeah, happy protecting privacy.
We're keen to work alongside you. So we do spend a lot of time providing advice and guidance and across our whole office. So we're a friendly regulator. So if you have questions, get in touch.
Thank you very much. Ngā mihi nui, everyone. Thank you very much for your involvement. And yeah, hopefully that's helped you understand a little bit about how to do notifications well. But as Susan points out, please do ask or call us because we're happy to help, and we may be able to help you do it well and help other people who may have been impacted. So thank you very much and appreciate your time.
Ka kite anō.